Hello, I'm Don Swanson. With us today is Robert Keach to discuss the history and future of Subchapter 5. Bob is an expert and well qualified to talk on this subject because he was involved from the beginning in the creation and enactment of Subchapter 5. So, Bob, great to have you here. Welcome.
Well, happy to be here.
So let's just jump right in. So could you talk to us a little bit about the involvement you've had in the development and enactment of Subchapter 5?
Sure, I'd be happy to. Well, my involvement really originally dates with being co-chair of the ABI's Commission to study the reform of Chapter 11. And as you know, that reform effort spanned a number of issues relating to Chapter 11, but one focus of the commission was how well or not well Chapter 11 in its traditional form was working for small business. And what the testimony before the commission revealed and what the commission's study revealed is that small businesses were not only not succeeding in traditional Chapter 11, or for that matter, even the old small business provisions, they were literally running away from the statute. It wasn't that people were filing and failing, although they were. It's that they largely were not filing at all. In other words, it just wasn't seen as a viable track for small business. And so the commission, which I co-chaired with Al Togut and which had many bankruptcy luminaries from around the country on it and assisting it, really focused on what were the root causes of that ignoring or running away from the statute. And we focused on a number of things, but the things that really popped out were the fact that given the way the absolute priority rule operates in a small, closely held business, it was literally impossible for most owners to retain their businesses through a Chapter 11 process. That was a big issue. The second issue, a really large issue, was that because of the structure of most small, closely held companies, the requirement of an accepting impaired class in order to confirm a plan in most cases was sometimes fatal, right? In other words, if you only have one class of unsecured creditors and you have a dominant recalcitrant creditor, your case is not going to be confirmed, right? And so that was a big issue. And then probably another overriding issue was just simply cost and time, right? Small businesses are not built to survive long stays in Chapter 11, and nor are they equipped to handle really expensive Chapter 11 processes, although many small businesses have complex problems that need to get solved. So those were three, really large issues that we felt any reform statute needed to attack. So the commission, as you probably know, made a recommendation around reforming Chapter 11 for what it called SMEs, small and middle-sized enterprises. And the commission proposal would have applied to businesses with debts of $10 million or under, and actually had optionality to go up to 50. And the architecture of that proposal was different than the way Subchapter 5 looks now. So really sort of the next step was taking that idea and turning it into legislation. And so that started, frankly, with many visits to people on Capitol Hill on both sides of the aisle and in both of the houses. My original testimony before the subcommittee of Senate Judiciary was before there was any legislation. And we were talking about what legislation might look like. And the way the legislation eventually came out is actually sort of reflective of that early hearing, because the people who testified at that hearing were me, a law professor, and a representative of the National Bankruptcy Conference, the NBC. The NBC had its own ideas about what a small business statute should look like, and it was very much what I'll call the Chapter 12 architecture, right? And I think if you look at the way what became the Small Business Reorganization Act of 2019, the way that turned out was really kind of a marriage of the commission's first principles of the things that needed to be solved and the NBC's architecture. right? So the current version of the bill, as you know, has very much a Chapter 12, even a Chapter 13-ish sort of architecture to it. But the principles I talked about, which were avoiding time and cost, modifying the absolute priority rule, and eliminating creditor veto, right? Those ended up in statute in a big way, right? Along with many other things, obviously. So that's how it started. That's how the bill came into being. And then we worked, we being, people were on the commission and primarily me, and then a number of other people, including some very dedicated Senate staffers, I might add, because as the world knows, right, the country's really run by very hardworking 20-year-olds on Capitol Hill. But some very dedicated staffers worked at drafting the original bill, which was very much, an effort of bouncing back and forth between the two proposals, but also, as always, the, needs and views of other constituencies with representatives on the Hill, like, creditor groups and the like. So we developed the original bill after many drafting exchanges back and forth. Then, of course, as you know, getting a bill drafted is one thing, getting it introduced is another, getting it passed is another very large thing. And then we moved on to the effort to get the bill passed. The story behind that is, I would say, a pretty typical legislative story. At the same time, we were trying to get the small business bill passed. And by the way, we originally were looking for a $10 million debt limit, by which I mean, debtors with non-insider, non-contingent, liquidated debts of $10 million or less would have been eligible. But at the same time, we were trying to get the small business legislation both introduced and passed. Other important bankruptcy bills were being introduced, one of which was the bill to fix the inequity towards veterans' medical and pension benefits and their treatment as to whether they would disqualify veterans from being eligible for Chapter 13, for example, or Chapter 7. And in addition to that, there was a desire to increase the debt limit in the Chapter 12 statute. In other words, to make more family farms eligible for that relief. What ended up occurring, of course, was that we combined those three bills into a package. And I've always said, if you want to get legislation passed, it's a good idea to hook your wagon to veterans and farmers. And so we were wise enough to do that with the advice of some very good people. Sam Giordano, the now retired former executive director of ABI. Sam certainly was instrumental in sort of helping us guide the process. And the combined bill, those three bills as a package, passed and became law. And the SBRA, what we now call Subchapter 5, was effective in February of 2020. And then, which is a good segue towards the history question, but I'll pause to let you talk. In other words, the bill first became effective, just before the start of the pandemic. One notable note is that in the original bill, we did not get a $10 million debt limit. We got the debt limit that then existed for the old subchapter, small business subchapter, which was about 2.8 million. Again, that's 2.8 million in non-contingent, liquidated, non-insider debt. And that was, as all things are, a compromise, right, to get the bill passed. And we always believed that, we would have to work to raise that, the debt limit, so we could make more small businesses eligible for the relief. And then, of course, the pandemic happened, and that's stage two of this question. So,
yeah, okay. Well, tell us some more history here.
All right. So in February, as I said, February 2020, the original SBRA or Subchapter 5 went into effect. There were largely issues then, as you will recall, about transitioning to the statute and whether existing 11s could, elect in. Largely, that answer was yes. But we were only working under the statute for about a month when everybody recognized that the pandemic was here, right?
Yeah.
I recognized, along with a lot of people, that the pandemic was going to be brutal for small business, right? And I was actually at my off-season house in Florida, getting ready to escape Florida and come back to Maine. But one of the first things I did was call my home state senator, Senator King, to say, look, this bill just passed. We've been working on it, but we need to make some changes to it because small business is about to get, had suffer a tsunami. And this bill is going to be necessary, and we need to make it more accessible to more people. I sent him a bunch of materials. He was a very quick study, and pretty soon I was working with his staff and connecting to Senator Grassley's staff, who had helped me draft the bill in the first place, to get at least a temporary increase in the debt limit. And again, we wanted to have the debt limit moved up to 10 million. As you know, we eventually ended up at 7.5, which is where we are today. And people always ask me, what detailed data analysis went into arriving at 7.5 and how did you get there? And the reality, of course, was that the bid from the other side, and you never quite know who the other side is in the legislative process, was to extend the increase in the debt limit for 6 months, which tells you what early perceptions were about the pandemic, right? It would be over within 6 months. But to go to a $5 million debt limit for 6 months, we wanted 10 million in permanent, and 7.5 is the midpoint between 5 and 10. So that's the science behind the $7.5 million debt limit. But we were able to get the debt limit increased as part of the CARES Act. If you remember the CARES Act, it was, 1,000 or thousands of pages long. And I remember knowing that it had passed in the CARES Act, but having to call my friend on the Hill to have them point out which page it was on, because I'd been through 500 pages and couldn't find it. I think it was on page 600 something. But so we did get that debt limit extended by the CARES Act. We have succeeded in extending the debt limit 2 more times now, most recently about a year ago. But the debt limit is due to expire in June of 2024. So we are back at work on the Hill, trying to have the debt limit at 7.5 rendered permanent. There's some talk of tweaking it up to 10, but there seems to be a fair amount of data that 7.5 may have, despite its sort of accidental nature, been the sweet spot. So it may be that we don't get an increase, but we keep it at 7.5. But that's the history of the birth and the history that brings you forward to today. I don't think anybody should presume that the rendering the $7.5 million debt limit permanent is a slam dunk. I do think it'll be a challenge legislatively because, frankly, everything is a challenge legislatively. For those people who watched the last legislative program that Jack Solana, who's one of the staffers I worked with, and I put on at ABI, along with Professor Lawless and Amy. The way things get done on the Hill these days is by acclamation or by unanimity. It's very seldom that things get done on floor votes anymore. So there's work to be done in the next year, but that may go into the part of this interview about the future. So
well, let's go there. That's the history. Well, let's talk about the future. Who was it that says that predictions aren't worth the paper they're written on, or they're tough to make, especially if they're about the future? Right. What do you see down the pike?
Yeah, look, I think one of the things that I think everybody knows kind of anecdotally by now is that Subchapter V has been a massive success, right? We are in the very, very early stages of developing the common law around Subchapter V. And as I have publicly stated a few times, I disagree with a couple of decisions that have come out. I think one of which is Cleary, and I think that is thankfully being ignored by virtually every court outside the Fourth Circuit. And I think the Ninth Circuit BAP just weighed in maybe yesterday. So I think that may resolve itself. There are a couple of other decisions that I think could be fixed. but I think the important headline here is that it's working remarkably well, right? The confirmation rates of Subchapter 5 plans are very high. I mean, historically high compared to regular Chapter 11. The cost, as I said, one of the things we wanted to do was shorten time and shorten cost. The cost figures are actually even below my estimation. So, I think that the consensus is it's working, right? It's giving small business a real chance to reorganize, and for small businesses to be saved. And frankly, I think if anything, Subchapter 5 has probably been underutilized to date. I think most insolvency practitioners know that the early stages of the pandemic were really characterized by government subsidy, right? The PPP loan process, a number of other sort of subsidies that I think allowed people to avoid having to file. That relief is largely gone. So I think we're actually going to see an uptick in filings, largely based on the increase in interest rates and supply chain and labor issues that we're all pretty familiar with. And in fact, it looks like that's true. I think Chapter 11 generally are way up this year. And so I think that Sub 5 will also see an increase in utilization. About the only piece of data we don't have, as you know, under the cram down provisions of Subchapter 5, a debtor can confirm a plan without any creditor agreement if the Subchapter 5 debtor devotes 3 to 5 years of NOI, what's known as projected disposable income, so it'd be projected NOI, to the satisfaction of unsecured claims. And what we don't have is data about what payment percentages are to creditors, and that data is now being collected. As you know, the ABI has formed a Subchapter 5 task force that is gathering data about not only that rate, but lots of other statistics around Sub 5. And so hopefully we'll very soon have some really solid data on percentages of payout to creditors. But again, anecdotally, I think everybody realizes that those payouts are higher, because it used to be zero largely. And almost anything above zero is an improvement. But I actually think we're going to see higher payout rates than are typical of even large Chapter 11 cases, for example. So I'm optimistic about that data. And I think armed with that, going back to the legislative process, despite what I would say is an instinctual pessimism about the legislative process at this point, I'm pretty bullish about the prospects of maintaining the status quo. I think there will be some opposition, but I think we have a really good story to tell. I do think it's working. The traditional banking interests, meaning secured creditor banking interests, are not in opposition. I think they think the statute works pretty well for them, right? They didn't lose any rights. They don't have to fund creditors committees, which they love. The cases are faster. They actually get some money on their unsecured claims. I think there may be some opposition from, credit card issuers and the like that is kind of manifesting itself as, quote, banking opposition. I think largely because, some of those creditors have programs of their own that they prefer to almost anything else. But I am optimistic that we'll retain the debt limit, but it's going to take some work. And I would encourage everybody who's listening to your podcast to write their congressperson about this. Email them constantly if you can. But I don't think we're likely to see an increase. I think we're going to maintain the status quo and be happy with that. I also don't think, I think one product of the Sub 5 task force will be to recommend, ways to improve the statute, in some cases, responses to decisions, Cleary is an example. I don't think this year is going to be the year to do any of that. I think that's, I think technical corrections and fixes are really a down the road kind of issue. I think we're still developing the common law. I think we want to, there are some places where you clearly get unanticipated sort of procedural surprises in terms of the way people are dealing with things. No legislation is perfect. We certainly don't claim this legislation is perfect. And if you're involved in the drafting process, you never achieve perfection because it's 99% compromise, right? People always ask, well, why did you draft it that way? And the answer is usually because that's the best I could get under the circumstances. It's not that we didn't realize there was an ambiguity, it's that an ambiguity was the best possible outcome. But I do think there'll be fixes down the road. I think you'll see legislative improvements, but not this year. I think this year is going to be about keeping what we have.
Well, thank you. Wow, this has been fascinating, and appreciate it so much. And we'll, as this thing heads down the road, if there's more to talk about, maybe we can have you back.
Well, I'd love to come back. I think there will be, well, listen, there'll be more to talk about one way or the other. I hope we're all smiling then.
There you go. All right.
All right.
Well, thank you very much. Bye-bye.
Thank you.